It is my pleasure to introduce the esteemed speaker for this workshop, Mr. Arunava Mathi. He is a registered Indian patent agent and trademark agent. Mr. Mathi is currently a partner at Lexicus, a distinguished DPIIT law firm specializing in intellectual property practices in Kolkata. With an impressive background in technology and law, Mr. Mathi holds a BTech in computer science and engineering, an ME in software engineering from Jadavpur University, Kolkata, a Bachelor of Laws and a postgraduate diploma in intellectual property rights. Having spent 7 years in software development and over 6 years in patent drafting, prosecution, and analytics, Mr. Mathi brings extensive expertise in IP laws, including trademarks and industrial design registration. We are delighted to have Mr. Mathi share his valuable insights and knowledge with us during this workshop.
So good morning everybody, and so good morning respected professors, my dear students, and all respected other persons who are present here. And it's an honor to be here in front of you, and thank you for coming. Saturday morning, you all appeared here to learn and to understand how we work on this patent drafting. So it's very thankful. So at the outset, I would like to heartily grateful or thanks to the committee of the IIT ISM for conducting this workshop on patent drafting. So this aims basically a very unique and very important aspect, because the whole patenting system is depend on how you write the specification. Because you are doing some invention, obviously you have some idea, you are implementing that one to solve some problem, and then writing that or implementing that in a specification, that basically you have to understand how to write and what things you should write, what things you should not write, and how to define the scope and how to write each and every part of the specification. So we shall discuss one by one in this workshop. So in between, if you have any questions, anything, so please let me know. So we'll I'll try to explain as much as possible so that you can understand the basic of things. And obviously the patent drafting is not a one-day course, it's basically a practice. Once you practice the thing, you will obviously evolve, but at first you have to understand the basic. So thank you. So let's start this workshop. And so this is the agenda of today's workshop. So at first, prior to starting the patent drafting, we want to understand what is patent, why we are focusing on patent specification and patent specification drafting, because what this patent gives us, right, that we have to first understand. Then we understand how you draft that specification to get that value, right? So for that reason, at first we will discuss regarding why this patent is required and what are the essential patents in our day-to-day life as students, and then what is patent, what are the patentability criteria, and then there are something that is not patentable. Okay, so that we will discuss. Obviously, we will discuss in short, and then what is patent drafting, and after understanding what can be patented, what cannot be patented, then we shall discuss regarding what is patent drafting, and after that Indian specific drafting details, because this drafting means there are certain legal requirement that has to be complied with, and that has been given in the Indian Patents Act. So I hope you know about the Act. So these are the rules and regulations that has been given in the Indian Patents Act 1970. And then we shall discuss regarding the content of specification. As I have just said, the patent specification is the most important document of the patent life cycle. So what would be the content of specification? Then obviously we shall discuss regarding some tips for effective drafting. What are the different types of claims and what is claims? And then we generally common mistakes we find out while we are drafting that patent. So we will discuss regarding that one also, so that we can obviate this mistake while we are writing the patent specification. And there's a sample of patent structure. I shall also show you some sample patent drafting. So I hope you will understand what this patent drafting is and how you should write all those things, so that, as I said, there will be no mistakes. So let's start. So why this patent is required? Okay. So as we understand, like these ideas are free until you patent them, right? What does it mean? That means like suppose you have an idea and you have implemented that one, right? Now, when you implement that one, it will be in the market. So obviously that should be in the scientific or technological background, right? Now you are solving some problem with your solution and you have implemented that one and you have, suppose you have shared with your friends or in the market, then that person can reverse engineer your implementation and they can again implement that one, but they will not give due credit to you because you do not have any protection over that implementation. So that's why the ideas are free, like anybody can use without your permission, they can implement that one. So that's why these ideas are free until and unless you patent them. So that's why we require the patent. Now, can you tell me, like, which inventions can't you live without? So we are using many things day to day life, right? There are many inventions. So give one example, just one example. Anything like pen, laptop, mobile. So these are all inventions. So these are came because of some problems are there, and we want to solve that problem. That's why it is there. So just any example, anyone. Okay, let's start then. So these are the most basic inventions that we are using in our day to life. Like the first one is the mobile, right? So everybody will have mobile, correct? So this is the technological invention. So let me give you like the background how this mobile came into the picture. So if we go back, suppose 50 or 60 years back, then at that moment how you communicate? Like you might not be aware of that one. So in any case, I'm just giving you the idea. So at that moment, like if you want to communicate with other person, then you have to write in a hard copy letter, correct? Then you have to post in a post office. Then the post office man or postman, whatever it may be, he has to check in which address you want to communicate. Then he has to physically go to that address, they have to deliver, and once that person receives that message, he will read, he can understand what is the message the sender wants to say, correct? So that is the primary mode of communication we had prior to 50 or 60 years back. So what are the problems that you feel in this communication method?
Time taking.
Perfect. So the time taking and the process, correct? So the time is like, suppose you want to send your message from one district to another district, it will take around 3 days. And it may take 1 month if you want to send from one country to another country, because it is a physical mode. So to overcome that problem, someone came into the mind that we can invent something which can be communicated over time in a real time mode, correct? So then they have invented the landline phone. Okay, so you know landline phone, right? Now, so what are the advantages we have in the landline phone? So in the landline phone, like if you want to communicate, you have to go to that landline and then you have to dial that number to which person you want to communicate, correct? And after dialing the number, you can connect with that person and then you can discuss with that person at that time in the real time, right? So it is solving the problem of time, correct? So previously it was 3 to 4 days or even if 1 month. Now we are communicating in a real time. But there is another problem. What is the problem? That landline is fixed. It may be fixed within your home or it may be fixed within your office, correct? So whenever you want to communicate, you have to go to that phone, you have to dial the number, and the main problem is whoever you want to communicate, he may not be present at that time, correct? So these are the problems that came into the mind. Then this mobile phone came into the picture. That means the land phone is not mobile with the person. So these mobile phones came into the picture. So in that mobile phone, you can carry with that phone. So whenever you want to call or you communicate, you can do that one. So I don't know, like whether you see that the fast mobile phone, like there are some buttons and small screen, correct? So in that mobile phone, again, you can communicate. Like you can only have voice over call. sorry, like in like voice, so 3GPP and all those things. And you can send message, right? But someone find out like the button, it is taking too much of space. So for that reason, we cannot use the whole screen. So someone try to solve that problem, and now that like touch screen phone came into the picture. So now we have the whole screen. If you want, you can type for that particular space. If you don't, then you can see the whole thing. In addition to that one, it is not only required for the communication, it provides many things. Like you can, so here it is given like it has camera. So it's so much improved, right? So it has camera, it has GPS, it has entertainment. If you want to see movie, you want to see video, you want to hear some music, you can do so. And even if you can do the payment. So nowadays, if you forget your money, you have forget your money, you can do the same. Like you can go and you do the UPI. Right? So this much of advancement came into the picture because some problems were there, and we are trying to solve that one, and we have implemented that one to reach today's mobile phone. Clear? So these things are the problem solution statement, and if you see, these are patents by various companies like Bell Lab, Nokia, Qualcomm, Apple. So that means when they patent it, what does it mean? That means whatever they have invented, they have protected it. So if any other person they want to build that phone, they have to take permission from the person who is patenting it. Correct? Now, like you say, like obviously because they are investing so much of amount for implementing or inventing the same. That's why the applicant has certain time period within which they have the commercial value. They can sell their product, they can give the license to the other person to get the money out of their investment they have made to get that mobile phone. Correct? So that is the advantages of having patent. Like you have the idea, you implement it, you protect it such that you can get something out of your investment. So if we do not have this mobile phone, then what it would have been? So there would be a communication gap, right? We cannot communicate with other person in a like immediate basis. Then there is loss of productivity. Obviously, now the communication is very much important, correct? So as you can take the example of today's session. So whenever it has been given to everyone can register and they know like when this session will happen. So immediately everyone has registered. So this is the communication, the faster mode of communication. So if you do not have mobile phone, if you do not have internet, you will not be able to communicate in such a way, right? So loss of productivity and isolation. Obviously, as we are together, so here is a group of 100 people. So if we work together, obviously the productivity will be more, right? If we work single-handedly, the productivity will be less. So that is the advantage of having the mobile phone, correct? Now there are two other examples, so I am not going as details as I have given for mobile. So there is internet. So that is also, and like that's a very good invention, right? So, and then the LED light. So LED light, so this is the LED also, right? So each and every place, whatever you see, you will feel that LED. Now this LED has been patented by Suji Nakamura along with like Isamu Akasaki and Hiroshi Amano. Their names is bit weird because they are Japanese, I think, and they got a Nobel Prize out of this. Okay, and without it, what would happen? Basically, it will have the higher energy beams. So we all know, right? Previously, the bulb which was, so that is of 60 watt, 100 watts. Now the same type of pollution that can be given by a 20 watt LED. So we are saving the energy bill, and also like it is a sustainable future because it generates less carbon. So that is the impact of your invention and having patented it. So you can like serve the whole society. So what is the tagline? So every invention we rely on today was once an idea implemented and that can be protected. What does it mean by protected? When we have the idea and you are implementing that one, please keep in mind you do not disclose it any other any places. Okay, so it should not be published. via online or whatever it may be. So it should be protected, and then it should be patented such that whatever implementation you made to solve a particular problem, that is the property of you, because this patent is the intellectual property, right? So this property came out of your intellect, so you are the owner of these. So someone who other person who wants exclusive right means you are excluding all other persons. So this is a negative right. Okay, what does it mean by negative rights? Negative rights means you are the owner of your property. Like you all know, right? Regarding your home or your land. Okay, so suppose you want to buy one home. So what you have to do? You have to go in a registered office. Then you have to register your name. Once you register it, you will become the owner. Correct? Now, once you become the owner, so certain rights will be conferred to you. What type of rights for the home? Like you can stay there, correct? Now you can give rent to, you can sell that product to other person, and as well as like you can destroy that, right? So these type of rights you will get once you buy the home. So similarly, that is also a like negative rights. That means you are excluding all other persons to using your home. So what are the example of positive right? Right to education. Like everyone has a right to educate, to get the knowledge, correct? The human right to be on in a good side, right? So these are the positive rights. But this like patent, or as I have just given an example of home or land, negative rights. Okay. So this exclusive rights means you are excluding all other person for the period of 20 years. Now why 20 years? Why not it's a lifetime? Right? Because see, this patenting system is a like balance between the like innovator or inventor, who is inventing, and obviously the society. Why? Suppose you have invented one drug. Okay, you have invented one drug that is very useful for a special type of cancer. So you have invented means obviously you have invested so much of money, so much of time. You have suppose hired a best mind within your company. So you invented that one, right? So as you have invented, you have patented, you got the monopoly, correct? Now once you got the monopoly, that means you can use it, you can sell it, you can offering for sale it. So suppose you are keeping the price of the drug is too high, that the general person cannot use that one, right? So it will give the inventor or the applicant the certain right that you can, as you have invented, you get some money out of commercialization. But on the other hand, the general person or the society, they will not get the benefit out of this invention, right? For that reason, what government has provided, they will get monopoly. So will give you, because without monopoly you will not be entitled, or you will not get that much of so you will not be entitled so to invent something, right? For that reason, government is saying we will give you 20 years of monopoly. Within these 20 years, you can commercialize your product, you can get money out of what you have invented, but after 20 years, it will go into the public domain. That means after 20 years, whatever drug you have made, if that are being manufactured by any public person, then you do not have any right. Understood? So that's why this patented right, that is the exclusive right, but it is only for the 20 years, and after 20 years it will go into the public domain, and any person who are there in this market, they can manufacture without requiring any permission from that person. So for that reason, this patent is an exclusive right that is only for technological and scientific invention, and it is for 20 years, right? Okay, so this patent I have said, like this is a new technical solution to a problem. So obviously a patent should be in the scientific and technological background, and it will provide a solution to a problem. So if you have problem, you have tried to solve that problem with respect to scientific and technological solutions, then you are eligible to get the patent. Okay. Now, as I have just said, so this is the exclusive right. So what are the rights that has been conferred? So these are the rights. Okay. So what is that? Making, using, offering for sale, selling, and importing. So what does it mean? That means I have just given an example of the drug, like the pharmaceutical drug. So once you invented that one, once you file the patent, then you can make that one without requiring any other person's permission. But if any other person wants to make it, they have to take your permission, right? Using, that means whatever drug you have used, you can use by own for your own purpose. But if any other one person wants to use, then they have to take your permission. You can sell it, you can offer it for sale, and also you can import it from other countries also. So these are the rights that will be assigned to you once the patent is granted. Now, this is a very important concept, that jurisdiction. Okay, it is a territorial right. So what does it mean? It means that, right? So in America, you do not have any right. So that's why if you want to get the right out of different jurisdictions, then you have to file the patent in different jurisdictions also. So this is a short video. I don't know, like.
What are patents and what do they do? Well, a patent is a government grant of a limited monopoly that allows you to stop others from making, using, or selling your invention for some limited period of time, usually 20 years for a utility patent. The government grants you this monopoly in exchange for your taking the time and going through the expense of writing down your invention and recording it in the patent office. Once your patent expires, the public is free to use your invention, and we say that your invention enters the public domain. Even simple inventions can be patented, small improvements of existing products. The requirements for getting a patent are that your invention must be new, it must be useful, and it must be non-obvious to others who are knowledgeable or who work in the area of your invention.
So, understood, right? So, like whatever we have discussed, that has been given in a short video. Okay.
What are patents and what?
Okay. So in that video, actually, there is one word, like there are certain criteria that needs to be fulfilled to get the patent. So what are those criteria? Okay. So at first of these criteria is the patent should be in the field of technology, scientific or technology. Suppose you want to do something in arts, so you will not be able to do patenting. For that reason, like there is another part of intellectual property we call as copyright. Okay, but for patent, that should be from the technological or scientific background. And there is another important word that is written here, for the product and or process. So what does it mean? Right? So suppose you have invented one machine, mechanical machine. So if that has some inventiveness over the prior art or already available machine in mechanical domain, so like the same domain, then you can file the product patent. Okay. Now, suppose you have invented a process. What type of process? Suppose, like we are using the same example so that you can understand it clearly. Suppose in the case of manufacturing the drug, the pharmaceutical drug, so you have invented one process by which you can manufacture the same component within a very less amount of time, or you are like getting some benefit, like some economical significance. So like suppose the prior process, it takes around 100 rupees to manufacturing a drug. The new process, whatever you have invented, it takes only 50 rupees. So is an example. So that means you are achieving the economic significance over the already existing process. So then you also can file the patent on that process. So the patent should be either the product and or the process. Okay. So there is another thing. So this is specifically in the Indian context. Invention should not fall under the non-patentability criteria as mentioned in Patents Act. Okay. So what does it mean by non-patentability criteria? Like in the Indian Patents Act, as I have said, there are some rules and regulations that they have been provided. So they have provided certain things within which you cannot file patent. Why? So we will discuss one by one. So there are total 16 points are there. Okay. Within that, for that subject matter, even that are coming from the science or technological background, you cannot file a patent. So that is defined in section 3 and section 4 of the Indian Patents Act 1970. So what are those? Like there is one slide which I'll discuss there in the next one. Okay. Now there is another thing like the invention should meet the criteria of three things. The first one is novelty, the second one is inventive step, and the third one is industrial applicability. So what does it mean by novelty? Novelty means that there's something should be new. So you have done something that other person cannot get it by googling, just googling. So there should be something new. So if something new is there, then you can showcase that my invention has the novelty. So if there is a novelty, if there is a lack of inventiveness, you will not get the patent. So you have to fulfill all three conditions: novelty and inventiveness and industrial applicability. So what does it mean by inventive step? Inventive step is non-obviousness. Non-obviousness means the person from the same field of technology, we call it a person skilled in the art. So that means the person, they are belonging from the same field of technology. So that your invention should not be obvious to that person. Because suppose I am from the computer science background, I am giving an example. So someone making invention in the pharmaceutical. So it is not possible for me to think, right? So the person from the pharmaceutical background, they can only understand whether this is obvious or not. So that is the reason, like it should be non-obvious to a person skilled in the art. So that's why I have written it should be non-obvious to a smart batchmate, because we generally know the batchmate are from the same technological background, right? So if that invention is not obvious to your smart batchmate, then you will get that inventive step things. Okay. And also there should be some industrial applicability. That means that should work outside your lab. It should not be within the lab. Right? So if these three conditions are met, that novelty and inventiveness and industrial applicability, then you will only get the patent. Right? So these are the basics. Like if you understand this one, then like you will understand like how to draft the patent. Okay, because if you do not understand the basic of the things, like it is not possible as to draft the right patent specifics, correct? So we have just discussed, right, the non-patentable subject matter. So there are two sections. So what are those sections? Anybody?
3 and 4.
Correct. Thank you so much. So these are the section 3s. Okay, so there are total 16 sub-sections are there. So I have given only 5 subsections, which are very important to you to understand that one. Okay. So the first one is section 3C. So section 3A to 3P. These are non-patentable subject matter, and another one is the section 4. Okay. So I have given a few things. So the first we will discuss regarding the section 3C. So what is section 3C? So this is the mere discovery of a scientific principle or abstract theory. That means, so see, I am repeatedly using the word invention. So do you know what is the difference between invention and innovation?
Sir,
Yes, please.
sir, at prime stage we can invent something that is not known.
Right.
And innovation is some changes or modifications that we are adding to make that invention more superior than the existing.
Perfect. Thank you. So this invention and innovation, you can file the patent. but discovery you cannot file. What does it mean by discovery? Discovery means there is something you are just discovering by way of scientific principle. For example, if you say that the sun rises from the east and sets from the west, so this is the scientific, you have discovered this one, you have not invented. So you cannot file this type of concept as a patent specification. Okay, and abstract theory, what does it mean? Suppose you are saying that I have invented one machine that doesn't require any energy, it will learn for and for. So you cannot patent that one because this is the abstract theory. Without the energy, the machine cannot fly. Right? So this is all about section 3C. Now there is another section that is called section 3D. So what is section 3D? Section 3D is the mere discovery of a new form of a known substance. So what does it mean? So again I am giving an example. Suppose like you have the pharmaceutical drug in a tablet form. Now you are saying I have discovered the liquid form of the pharmaceutical drug. So what you are doing? You are just discovering a new form of known substance. You are not inventing anything. Then you cannot file the patent. But there is a tweak. What is the tweak? If you showcase that this new form has some enhanced efficacy over the already available product, then you can file the patent. Right? So you have to showcase the enhanced efficacy out of that one. And section, so just a mere discovery of a new form of known substance, you will not be eligible to file the patent unless and until you can showcase some enhanced efficacy. Right? Now section 3I, that is regarding any process of medicinal, surgical and curative treatment. So what it means? Suppose you have invented a process of operation, like that is from the medical background. Okay. Suppose you have invented some process of operation, so that is not patentable. Why? Any idea? Okay. So the process of operation is a very basic thing. If you protect that process of operation, the other doctor cannot do the same. Correct? So this is the basic thing which requires for the human being to be alive. For that reason, section 3I pass the process of medicinal, surgical and curative treatment. But there is again another trick. If you invent any machine or product that helps you to curate any like surgical or like any oil, then you can file the patent. So the process is a non-patentable. So here it's clearly written any process for medicinal, surgical or curative treatment. But if you invent the device, you are allowed to file the patent. That you have to remember, right? Then section 3K. So that is very important for the person who are from the computer science background, because here it is clearly written that a mathematical or algorithm or computer's program per se. That means if you invent any mathematical expression, you cannot file that one. Now there is another thing. While I am saying that you cannot file, that means you cannot claim that one. You cannot claim that mathematical expression into a patent specification. But suppose you have claimed one process, and to implement that process you need some mathematical expression, you are allowed to like mention that one. But this mathematical expression is not allowed to put in the patent claim. And then the algorithm. Algorithm means mere algorithm you are defining without having any hardware thing, then you are not allowed to get the patent. And the computer program per se. What does it mean by per se? Per se means the computer program itself. Okay. That means whatever computer program you are writing, it may be in C, it may be in C++, it may be in Java, it may be in Python. So whatever code you are writing, that code itself is not a patentable subject matter. But again, there is some tweak. The tweak is obviously you are writing code to implement something, to have some process, correct? To solve some problem. Now, if you claim that process, you are not claiming the computer program per se. You are claiming the process and you are saying that this process are solving some real life problem, then you are allowed to get the patent. Right? So how we overcome the non-patentable subject matter, you understood, right? So this mathematical expression, algorithm and computer program per se, these are non-patentable. But if you represent it in a different way, you can get the patent. Right? So that is the beauty of patent drafting. So you, like, anybody will know, like, yeah, I have done the computer program per se, I have computer program to implement that one. Like, if you simply write in your claim that I have done this in C++, you will not get the patent. So how you are express your invention with, by way of patent specification, that is the beauty of patent drafting. Now the last thing is 3M. Okay, so that is a mental act, correct? So you are not allowed to get that patent on the mental act. Got it? So these are the few examples. So section 3A2 you can understand. So that is easy to understand. So there are some quiz. So let me know. So the first question is, which of the following is non-patentable under section 3 of the Indian Patent Act? The first option is a new chemical compound with therapeutic effect. The second one is the mathematical formula. The third one is a genetically modified plant, and the fourth one is a mechanical device for mining. So what would be the answer here for the question number 1? Right. So that will come under section 3K. So this mathematical formula we cannot claim as a patent, right? But as I have said, like suppose you have defined one one process, and to implement that process you require some mathematical expression. You can write in the detailed description. So there is no bar on that one, but you cannot claim that mathematical expression in the claim part only. So what is the claim? How to write the claim? What is the scope of claim? We shall discuss one by one. Okay. So just understand the basic things at first. Okay. Now the question 2 is Newton's law of gravitation. So is this a patentable subject matter? No. Right. So it will come under which of the subsection? 3? No. 3C. See, mere discovery of a scientific principle. It is not mere discovery of a new form of known substance. It's a scientific principle he has merely discovered. So that is the Newton's law of gravitation. That will come under section 3C. So suppose Newton wants to claim the patent, he will not get it. That will, like in India, he will not get it. But in US, like there is no concept of section 3 and section 4. There is different type of concept. Okay. So in India, if Newton wants to get the patent, he will not get it. Right. Okay. Now the question number 3. So a new formula for a faster multiplication of two numbers. Is this a patentable subject matter? No. Because this will come under section 3A. Okay. So this is the formula, that is the mental act you are doing. Okay. So I hope like at least basic concept you understood, right? Like what is patent and why we require that one, and like what are the different type of non-patentable subject matter. So something you get it from this session, right? Okay. Now we'll enter into the patent drafting. So the main of this today's workshop. Okay. So what is patent drafting? Now we understood, like if you solve any problem by scientific technical solutions, you are allowed to file the patent. Right. But how you file the patent? Suppose you have invented one machine. So you just submit your machine to the patent office. It is not possible. right? So even if you submit the like suppose the machine, if even you submit the machine to the patent office, they will not be able to understand the internal implications, because as the layman, from the outside you can see like I am giving this product, this is getting the output. It's a black box type of thing, right? So even if you submit that particular device, you will not get patent. So how you get patent? You have to write that invention in a document. So that document we call as a patent specification. So only the physical, so if you give the physical embodiment, it doesn't have any meaning, right? So how it is working? So the working functionality of your invention will add value and you will get patent on that functional implementation. So there is another type of patent that is called the design patent. So what we are discussing, it is the utility patent. Okay, so what does it mean by design patent? Design patent is only how the machine looks like, the aesthetic beauty of your device you can file. So that we call as a device, like the design patent. Okay, but what we are discussing today, that is the utility patent. Okay.
Now,
Yes.
please clarify that design patent, that terminology is not there in India. Otherwise, people get confused when they try whether I should file design patent or utility patent.
Okay. Yes. So just a basic difference of design patent and utility patent. In design patent, you cannot claim how it is working. What you can do in design patent, you can only file how it looks like. Right? From the outside, how you can see that product. So I'm giving an example, right? So everybody know like the BMW car is more soothing to our eye than the Maruti car, correct? So this is basically how it looks like. We do not know how the working functionality of the BMW car and how the working functionality of the Maruti car. It is from the outside view. So this outside view, how it looks like, you can protect by way of design patent. Why? Suppose like there is no concept of design patent. So suppose BMW manufactured one car and the Maruti copy and paste, because Indian we are very much aware of the copy and pasting, right? So we just copy and paste the BMW car and we just manufacture it. So there will be no protection, correct? For that reason, this design patent give protection how it looks like. It will not give you the protection how it is working. Okay, so from the outside view, if you want to protect how it looks like, you go for the design patent. And suppose obviously the BMW has many functionalities which are unique in nature, correct? So that functionality, if you want to file or if you want to protect, you have to go through the utility patent. Clear? Okay, great. Thank you. Now, yes. So the drafting is the process of writing a patent specification to protect the invention. So the working functionality of the patent, how you are write that in a patent specification, that we call as a drafting. Okay. So in a patent drafting, it must meet the legal and technical standard as defined in respective acts. Okay. So the inventor who are inventing things, they know about the technical implications. They know how to implement all those things. But as the government is providing some protection on your invention, there must have some legal requirement. So for that reason, when you are preparing the patent drafting, it must meet the legal as well as the technical standards as defined. Why I have written the respective acts? Because in India we are calling as a Indian Patents Act 1970. In US there is different 35 USC. Okay, so that has to be meet the requirement of different countries' legal requirement and also the technical standard that has been defined in that respective act. Okay, so there is balances technical clarity with legal enforceability. What does it mean? That means legal enforcement is required, right? Because you are filing patent, only get the enforcement if anybody is violating the rights. So the legal enforcement is required, but to get the legal enforcement, if you are not able to clearly specify the technicalities of your invention, you will not able to protect your invention properly, right? To protect your invention properly, that's why you have to give that patent specification with utmost technical clarity. So each and every component, what are those components? Because see, when you are inventing, other person may not understand it, right? Because although they are from the same technology, everything is not possible to understand, know by other person. So you have to write each and every component, like at least you have to give some basic things, right? What this component is doing, what are the interrelation between those components, and by way of interaction between those components, how you are getting that your invention, like how you are solving the problem. So each and every technical detail should be there. Obviously, you have to keep in mind the legal things also, because I will like there is one patent like this slide I will discuss. So suppose I have just given, right, like section 3 and section 4 that you should not write. So while you writing the patent specification, please keep in mind to avoid those words, because once you write those words, immediately the patent office will jump into it and they will give the objection. So that's why while we write the specification, we have to keep in mind whenever you are choosing the words is very important. Like each and every word has the value. So when you are choosing the words to write the patent specification, you have to do it very carefully. So the words which are written in the section 3, or like there are few words like there is one slide I will discuss. Okay, so that we have to avoid while we write the specification. So this patent specification is the mother of all. What does it mean? That means this actually forms the basis of examination, opposition and enforcement. That means whatever you are writing in the patent specification, that patent specification will be examined by the patent office. Okay, so just I am giving you like the life cycle of patent so that you can understand. So at first, like there is a searching that is called patentability searching. Okay, so what is it? Like it is just whatever you have invented, like whatever you are thinking that is new. Okay, so by way of patentability search, so in patentability search, basically you can search through the database of patent database as well as non-patent literature throughout the world, and you can find out whether your invention is novel or inventive. So once you perform the patentability search, so you found out that whatever you have invented, that is unique. Now you prepare the patent specification. Okay, keeping in mind whatever uniqueness is there, that should be in your patent claim, because the patent claim is the heart and soul of your patent specification. Now once you draft for the patent specification, you have to file before the Indian Patent Office. Like this, that is simple. Like suppose you want to buy one home, right? So you have to go before the register office, and the seller and buyer has to present, and they have to sign and transfer their rights. So here, like the patent specification is your property, it's your intellectual property. Whatever you have invented, you have to write it down in the patent specification. Now you have to file before the Indian Patent Office. So that is the registering office in India. In US, the United States Patent and Trademark Office. So we call it as USPTO. So you have to file before the respective offices within that jurisdiction. So once you prepare the patent specification, you file it before the respective authority, and that authority again will search what you are claiming that is unique or not. So they will again perform their patentability search from their end. Okay, they have their database. They will obviously search the worldwide database whether it is a patent literature or non-patent literature. So they will perform their own search from their office. Now, once they search it, they will raise the examination report. Okay, Examination report means suppose they found out two documents that is very similar to your invention. Okay, they will cite two documents and they will say your invention is not novel or it is not inventive with respect to these two documents. Okay, so once this first examination report has been generated by the Indian Patent Office, now it is the applicant's responsibility to respond or to reply or to obviate the objection that has been raised by the controller or examiner of the patent office. Now it is our responsibility to say that no, like whatever you are saying that is absolutely wrong. These things are not present. These things are not present in our like in the prior document. This is our uniqueness. Okay. So by that way you have to file the response to the objections that has been raised by the patent examiner or controller. Once you file the response, that response being again that will be examined by the examiner or the patent office. Okay, they will say like whatever you are giving the argument, whether that is correct or not. So suppose they found you have not provided the appropriate argument with respect to their objections, they will proceed for the hearing. What does it mean by hearing? Hearing means that is the video conferencing mode, the hearing would happen. So the like patent agent or the applicant, these only two persons are eligible to appear before the controller of patent. So they have to appear before the controller of patent and they have to argue like we have written these things, this is correct because these things are new that has not been implemented previously by any patent or non-patent literature. Now in that hearing, if they are satisfied, yes, whatever you are saying that is correct, they will grant your patent. Otherwise they will refuse it. Okay, so this is the overall life cycle of the patent specific patent application, and once it is granted, then from the date of filing of the patent application, 20 years from that date, your patent is valid. You will be aware obviously that you have to pay the renewal fees, so that is the difference to it. But this is the overall life cycle of a patent application. So it is same in India we call as a examination report, then hearing. In US that is the non-final office action, final office action. So there are different terminologies they are giving, but the process are more or less similar. Okay. So now you understand the last thing, right? That forms the basis of our examination, opposition, and enforcement. That means whatever patent specification you are filing, they will only see that specification only. Obviously, they will not know what machine are doing, what you have invented at your home or lab, right? So they will only see that specification only. Based on that one, they will doing the examination. So if there is any opposition means if any third party finds that you are copying their invention, you have filed that, so they can file the opposition also. And also enforcement. Enforcement means whatever invention you have claimed, you have enforced that one. Okay. Give me that.